Good morning, everyone, and welcome back to this week's episode of the Digital Law Podcast, brought to you by Digital Law and produced by Anson Evaluate. As a bit of background, we're a law firm that works solely on technology, cybersecurity, and legal issues. In each episode, we look at stories in the law related to digital technology from around the world with a specific emphasis on data protection and cybersecurity. I'm Amelia Davies, an apprentice solicitor at Digital Law UK, and I'm joined by my colleague Peter Wright. We're just going to be running through some of the news stories that have been coming up this week. So I will pass over to Peter to introduce himself, and then we will get started.
Hi everyone, my name is Peter. I'm a solicitor and the managing director at Digital Law, and we've got a good amount of international stories to bring to you this week. So I'll pass back to Amelia to kick us off.
Thanks, Peter. So we are starting in the US this week, and we are discussing Meta. And I mean, is there a podcast where we don't discuss one of the big three? I would struggle to find one that we haven't. So we are looking at Meta and the Oversight Board. And so this is the independent body that reviews how the owner of Facebook moderates online content. And essentially, this specific story, we're looking at whether the firm should label fake posts rather than remove them. And when we say fake posts, we're specifically talking about here a fake video of US President Joe Biden that was circulated on Facebook. And essentially, they fell on the side that they did not need to remove the video, but rather label it. However, specifically, we want to focus on here the fact that this video exists. And it is, in fact, a fake video of President Joe Biden. And we are only at the start of the year and around 10 months away from election season. So, Peter, I will pass over to you to discuss this in more detail.
Yeah, so I think there's two big takeaways from this story, really. The first one is that in this instance, the Oversight Board, which is the sort of corporate governance structure that Meta has put in place to provide views on how it is operating and enforcing its own policies. And in this instance, the Oversight Board has said, well, actually, it was correct not to remove this fake video because actually the fake video didn't contravene the wording of Facebook's own policy on manipulated media. However, at the same time, they've said that policy itself is incoherent and not clear, and that, in fact, it probably does need to be rectified. So they're basically saying, in this instance, based on what the policy says, the video shouldn't have been taken down, but we may want to revisit that policy so that videos like this are taken down in future. Second big takeaway, why is this important? It is election year. We are now about 10 months out from the US election. This was a fake video of Joe Biden that was more than likely a AI creation, fairly easily put together with freely available AI products. And already there have been other instances of material like this having an impact in the US primary campaign. Indeed, a lot of voters in Iowa ahead of the Iowa caucuses, I believe, ended up being contacted by a robocall machine that was basically saying to Democrat voters, it purported to be Joe Biden saying, and it was basically, here's a message from the president saying you shouldn't take part. There's no need for Democrats to vote in this. Literally, it said this primary or this caucus is a bunch of malarkey, which is one of Joe's words. So you would perhaps be more inclined to believe that it was true if it sounded like the president and used his syntax and his words. You might be more persuaded that it was true. Whether it had any impact on turnout on the Democratic side of the primary, who knows? Because really, it's that the campaign at the moment is pretty much a one-horse race for the president as the incumbent, as these things often are. But the point is, it was still used more than likely by obviously someone who wasn't sympathetic to the Democrats to try and influence the turnout and the vote. So we're already seeing the impact of AI in elections, and it's then it being shared widely on social media. And we have to bear in mind that it isn't just the US. There are elections across the democratic world this year. I believe it's something like 80 different countries have got a general election of some shape or form. This week, it's Pakistan that has gone to the polls. In January, it was Taiwan. We have the UK going to an election more than likely at some point before the end of the year. Though Prime Minister Rishi Sunak could push it till January 2025, strictly speaking, if he wanted to, though the question is, would you want to? Would it make any difference? But events, who knows? But the point is that in the UK, it's not strictly set in stone when the election will be. But as I say, for 80 odd countries, it will be the case of an election this year. And increasingly, because AI is so freely available and easy to use, you don't particularly need to have any particular expertise now in the operation of this technology to be able to actually create quite believable looking audio and video. That the approach of platforms such as Meta to how this content is going to be treated could potentially have a real impact in such an important year.
Thanks, Peter. I think this is a story that we will certainly revisit as the year progresses, as you say, because whilst we have focused mainly on the impact of AI on election year, we have seen progressively more and more deepfakes of celebrities. And if you were listening to our last week's podcast, I think we discussed how Taylor Swift and was it La Crusette or Tifa, something she had been seen to be promoting the crockery brand, and in fact that was not the case, and it was a deepfake. So certainly a story to watch for the rest of this year. Moving then back across the pond, we are checking in with the UK Information Commissioner's Office, the UK ICO, and we are looking at the fact that they have been urging developers to prioritize privacy by design. Try to send that 3 times in a row. And so privacy by design. Peter, can you explain this term to our listeners before I dive into why this is so important?
So the idea of privacy by design is that systems, apps, websites, and indeed tech systems that firms might build themselves for their own use internally. The idea is that when you're building a system that will be used to either collect or store personal data, that you think about issues around privacy at the outset. So the idea is that you would incorporate strong security measures. You would think about only, minimizing the amount of personal data that you have to collect, only collecting the personal data that you have to in order to carry out the operation of the system, i.e. that you aren't collecting any more than you have to, which Google has been hit for in the past when it's Google Street View cars back about 10 years ago now, they were collecting information about local Wi-Fi networks. And it was pointed out, Google, you don't need to be scanning everyone's Wi-Fi network as you drive your cars up and down streets in order to put together photos that will form the Google Street View system. So I always use that example because I think it illustrates well the fact that you should only be collecting what you need to do the thing that you've set out to do. So hence, you only collect the data that you need, you do it in a safe, secure manner, you keep it safely and securely. And the idea is that you incorporate these priorities into the architecture of your system. So you don't sort of go, right, let's run off and build something that's got great functionality, and then at the last minute go, oh, actually, we need to think about security and privacy. The idea is you do this at the outset, and you evidence that you've done that at the outset, put it into a data privacy impact assessment, for example, and then you can use that to demonstrate to the regulator, in this instance, the UK ICO, that you have considered privacy by design at the outset, and you can therefore demonstrate compliance.
Thanks, Peter. So relating this back to the story here, so the ICO is reminding all app developers to ensure they protect users' privacy following the regulator's review of period and fertility apps. So this is looking at the fact that last year the ICO was reviewing closely period and fertility apps to understand how they process personal data and identify where there is any negative impact on users as a result. And so you may be thinking, well, why is this important? This is because when we are looking at apps which will be collecting data such as health, and we are in a world now where the health and fitness industry is booming, This is what we would class as special category data. And as special category data is defined, it does require a high level of safety and security when you are processing this. Therefore, where we are seeing more of these apps, privacy by design is a must, irrelevant of obviously if you are developing a period of fertility app or another health related app. Privacy by design must be at the forefront. And I think it's very important the fact the ICO is bringing this to our attention, because as Peter and I were discussing before the call, we have worked with quite a few clients in the past where they have been creating products, apps, websites with health related data, and explaining the importance of having systems in place to protect data that's collected does not always register from a development point of view.
Exactly, and it's so important to be thinking about these things from the outset. Um, I have in the past spoken to developers of these sorts of apps, and it's literally that sort of the excitement. Oh, we've got a great idea, and let's run off and work out how this should work. But they don't want to start thinking about what they see as the dull, tedious legal stuff. So when there's someone like me there saying, well, hang on, you need to think about the totality of the data that you're collecting and making sure you're thinking of security from the outset, they simply don't want to hear that. They want to actually run ahead with the great idea they've had. And so therefore it can be a bit of an uphill struggle in our experience. They don't want to consider these things, and that's why the regulator is now making the point that yeah, the law does say this, and we are looking at this, and we are looking to regulate and enforce it. It is particularly important given, as you correctly say, Amelia, the proliferation now of health-related apps. We've gone from sort of the advent 10 or so years ago of the sort of the wearable tracker, the Fitbit, and then the smartwatch that's looking at your steps and looking at your heart rate, through to steadily more sensitive and invasive apps that are doing things like, you've got the Zoe app that looks at your blood sugar levels, and also they do things like blood tests and things to check your cholesterol and check the way that your systems are working to try and tailor your food to the way your body operates. Now, of course, to do something like that, you're going to need quite a lot of quite specialist data in order to carry out that sort of survey, and that's all being collected and then tracked through an app. So when you might look at the fact that an app like Zoe has been incredibly successful and is on TV and seems to be in virtually every newspaper and magazine and social media platform saying how great it is. Other people then think, oh, that's good. Why don't we do that for exercise? Why don't we do something like that for loads of different applications? Increasingly as well, particularly in the UK where the NHS is struggling, I think there is a perception that people think, well, if I'm tracking everything, I can hopefully keep track of any potential illness I have before it becomes a problem. So they've already talked about the growing industry of the worried well. People that are perfectly fine but are worried they might come ill, don't particularly want to get ill because they know that it might affect their family, their work, their health. And therefore, they're increasingly spending more on apps to feel reassured.
It's funny you
So that's
mentioned this,
where it's
Peter,
so
actually,
important to do this.
because I recently updated my Apple Watch and I was asked, did I want to enable a feature which means my watch can take an ECG to check for any abnormalities in my heart rhythm? And I was like,
Wow.
wow, that's quite interesting. And it's like you say, and you were saying about how, taking pressure off the NHS, and that was actually part of the information that it gave you in terms of, do you want to accept this sort of
Mm.
functionality? And I was reading through, I was like, oh, crikey, that sounds like great news. You can track this and I can show, if I ever have any heart problems, which I don't, and go into the doctor and say, well, this happened on this date and this happened on this date. But there is that kind of feeling in the back of my head where I'm like, okay, this is quite a lot of data for just, me to be sharing with Apple. And do they have the right level of protection in terms of, is this data ring fenced? Can they access it? And it's like you're saying, more and more apps are doing this. And this is just a wearable, and it's the kind of a free version, if you like. There are other apps and other wearables that you can have, which you do pay for a premium for, where you get far more accurate results. And it's like, oh, crikey, if you're this accurate about my health related data, are you putting enough protection in place to protect it?
Exactly, particularly when sometimes it might be built on systems and tech that wasn't built with that at the forefront. You've also got to bear in mind with something like Apple, of course, that that is built therefore on a system designed for the US data protection laws, which are very, very different from those in the UK and Europe. So then they'll very often have tried to sort of retrofit those US designed and operated systems to make them compliant for Europe and the UK. But sometimes there can be problems. And certainly you'd probably have an issue being able to demonstrate that a lot of that US tech really does have that element of privacy by design, because it probably wasn't. I mean, they're famous for for innovating, running fast, and breaking things, and then you'll only end up sort of thinking about these issues around regulatory compliance at the end of the process rather than at the outset, and that's the point of privacy by design.
Thanks, Peter. I'm sure we will be seeing more from the regulator on this as the year goes on, because, like you say, it is very important, probably one of the most crucial aspects to consider from a developmental standpoint when you are looking at regulation and compliance. Sticking with the theme of compliance, we are with the ICO looking at their cookie crackdown. So if you are a regular listener, you will likely have heard our discussion on the cookie crackdown before Christmas. However, I'm pleased to report that the ICO has received quite a positive response after naming and shaming people sending out letters that you are not compliant. And so of the 53 organizations that they contacted, 38 have allegedly changed their cookie banners to be more compliant, with 4 others committing to reach compliance in the next month. So this is kind of great news in terms of understanding that actually people are not using cookie banners in a non-compliant way to be nefarious. It looks like realistically they just don't understand what should and should not be in a cookie banner. So more the fact that there's misinformation or not a lack of understanding in terms of cookie regulations, rather than the out and out thing, well, we want to collect as much data as we can, tough. Read it properly, otherwise we'll collect everything. And so, Peter, what are your thoughts on this?
This is really it's interesting that this sort of follows that earlier story we've just done on privacy by design, because this is another element that we're always talking to clients about, and very often it's a bit of an uphill struggle to make them realise this stuff is important. And the ICO is saying here, well, actually, it is important, and we are proactively reaching out to organisations to make sure that their cookie banners are compliant. The issues around demonstrating compliance with the privacy and electronic cookie regulations that contain the rules with regards to the operation of cookies, that has changed over years with regards to both the introduction of GDPR and then the UK's Data Protection Act 2018. One of the key things is that, for example, the banner should allow users to both accept or reject cookies. And the principle is that you should have the ability to reject cookies, but still have a degree of functionality to access a website, use its tools, etc. And then also you should have, alongside that, the ability to see what cookies are in operation, what data they collect, and there needs to be total transparency on that. And we continue to find that many cookie banners don't have that accept or reject feature. And also we often find that it can be quite difficult to actually tie down what cookies are in operation on a individual platform. Sometimes there can be some ambiguity. The client might be under the impression that there are no cookies in operation when actually there are. Sometimes there can be a range of different cookies from then different sort of sub-suppliers. So it could be that they're using a particular platform for contact mining and email marketing, and their cookies could be installed, and they might not be reflecting this on the cookie policy that shows that those third-party cookies are in operation. And depending on the type of site, if it's one with a lot of traffic, very often there are more cookies of that type to try and mine analytic data from the visitors to it. Should also add that it's still the case that if you've got a e-commerce portal that's being used to sell goods and services to the user, of course, you're going to have more cookies present to allow the functionality to have those transactions taking place. And again, it's important to make sure that all of those cookies are reflected in that cookie schedule. There shouldn't be any ambiguity in terms of what is or is not going to be installed on a user's device. And finally, of course, Amelia, you'll know that we have had a number of our clients come to us saying we've received letters from users who have said, I've had cookies installed on my device having used your platform, and I'm very upset about this, and I therefore demand compensation. Now, um, they've even ended up threatening to take organizations to court over this. Very often the threat of compensation is an empty one, but the point is that sometimes some organizations will end up receiving those letters and just paying money to a sort of spurious claimant like that, when arguably they shouldn't. But the point is they do it because they then known that their cookie compliance is not actually correct.
Thanks, Peter. And I certainly think we will keep seeing the ICO pushing forward on this because, as we may have discussed in previous podcasts, it's fairly low-hanging fruit in terms of kind of being able to tackle cookie compliance. It is fairly low-hanging fruit for the regulator. You can tell when a cookie policy does not have that transparent level of detail, and I think we'll see more and more throughout the year from the ICO on this. Moving away from the ICO somewhat, we are now going to be talking about one of the other big three that we mentioned most podcasts, and that would be WhatsApp. So this week we're looking at WhatsApp in the workplace and kind of from an employment perspective, really. And this is where we are considering the fact that there was an incident where an employee who successfully sued her employer after a colleague refused to let her back into a work WhatsApp group while she was on maternity leave. So this is quite interesting use of WhatsApp here. Obviously, most organizations now, to generalize, are using WhatsApp in one way or another. It is so heavily used by members of the public, organizations, companies alike for communication purposes. And here it's interesting to see that actually, this is just but one case that we're discussing, but there have been many cases where employment tribunals have awarded monetary figures for people not being included in something as simple as a WhatsApp group chat. Peter, I'll pass over to you on this.
Yeah, and it's interesting you say, Amelia, that the proliferation of WhatsApp now means that this is something that applies to probably the vast majority of organizations out there where staff are using WhatsApp or something similar, like, say, Signal or Telegram, to stay in touch. We know that now there are hundreds of thousands of employees across the Europe, the UK, and the US who are working from home on a regular basis post-pandemic. The cat is sort of out of the bag after that, in that it's actually now increasingly rare for people to spend 5 days a week in the workplace, and it could be 1 or 2 days a week working from home. And therefore, very often you've got people communicating informally via things like WhatsApp, because they appreciate that not everyone is going to be in the workplace. So it's like the WhatsApp has replaced the old sort of water cooler or conversations around the coffee machine and in the kitchen that used to take place, because all of those people are not actually now physically present, but it might be that you want people to be aware of a discussion or issue. But as is almost by definition, you therefore get the sort of blurring between that workplace and personal life boundary. Obviously, when you're at work, people do discuss personal lives, everything from what you've done at the weekend through to it could be that you're discussing things like the fact that everyone might be making arrangements for the Christmas party or going on a team building event or something. All those are the sorts of things that might conceivably be discussed on a WhatsApp group. So you've got that, as I say, that blurring between public and private. But increasingly, there are two major consequences of that. One is that if someone is excluded from that group, that could be an issue. And in this instance, we've got instances of people being awarded more than £100,000 for being excluded from a work WhatsApp group. And in particular, here we've got someone who left to go on maternity leave, and when they came back, they were refused access to the team WhatsApp group. So, and the courts found that yes, you while some people might welcome the isolation of not finding out what's going on at work, arguably it is a key part of being able to do your job now to be part of these groups, and therefore six-figure settlements and awards from tribunals are being made as a result. The other thing to consider is that discussions on WhatsApp can be disclosable when it comes to incidents where there are claims in the employment tribunal. It is also conceivable that if you have internal complaints that are made, anything from different behaviour that has caused a problem, and one employee makes a complaint about another, or an external party makes a complaint about an employee, then that internal process is likely to also require poring over not just copies of emails, which we're probably more familiar with now, but also increasingly printing out exchanges on WhatsApp. And you'll know that it is actually fairly straightforward to actually produce from a WhatsApp discussion. You can print that discussion, and then that can be used potentially as evidence. We'll draw a veil over the difficulties that some politicians have had in producing their WhatsApps to the COVID inquiry, both in Scotland and in England. But the point is that the inquiry felt that in order to do its job, in order to have all of the relevant evidence in front of it, it needed to have those WhatsApp discussions between ministers, advisors, secretaries of state, etc., in order to get a full picture of what was being said and whether that would have had any impact on the decision making that then took place. So increasingly, this technology is an integral part of the workspace, and we're seeing employment law rapidly saying that these exchanges are written down and do constitute evidence. So it becomes disclosable, it becomes something that can be relied on, and tribunals are making decisions based on both the presence of WhatsApp exchanges or indeed the lack of or exclusion from those sorts of discussions as well.
I think the interesting point that we say when we're in the office is like, would you be happy for this to be read out in court? I think that's a pretty good rule of thumb. Would you be happy for whatever internal comms, emails, etc., whatever you've written down, would you be happy for that to be seen by others? And if the answer is no, you know the answer.
Yeah, absolutely right, Amelia. I used to work with one colleague who said, you have to bear in mind, think of this extremist. Would you be happy with the sentence you've just written being read out in open court? If not, maybe think twice about sending it.
Precisely. And I will leave our listeners with that one on that story for now. And moving on to our final story of the day. And if you're a fan of Taylor Swift, get excited. We will be finally talking about her in our podcast. And you might ask, well, how does Taylor Swift link to what we would discuss in terms of technology and cybersecurity? Well, we are looking at the Universal Music Group, which represents artists including Taylor Swift, Drake, Adele, Bad Bunny, and Billie Eilish. And they say that they will be no longer allowing the music on TikTok now that a licensing deal between the two parties has expired. And I can confirm now that all of the music has now been removed from TikTok. Therefore, the TikTok videos that had existing music have now got no music at all in the background. That has been removed. And essentially, a lot has gone quiet. And this is a very interesting story in terms of licensing. So, Peter, I will pass over to you to discuss in more detail.
Yeah, so those that are regular users of platforms like TikTok, and also for that matter things like Instagram and Meta's Reels, which is just the sort of the pale imitation of TikTok, which doesn't have as good an algorithm, I'm told by the people that build it. For that matter, it is established that very often videos are more popular with music in the background, and usually it will present options. So when you're building your video, you can sort of select and start typing, and it will give you a load of options based on the title or artist that you're looking for that you can then easily sync up with the video that you're building. And in order for that to happen, there are actually licensing agreements in place. So in this instance, you've got a large music group that has a large number of artists on its books, is now saying we do not TikTok allow you to have the music of our artists in the background on these user-generated videos. So it will no longer be available for those who are looking to build new videos in future. And for those that's already up there, unfortunately, it'll end up going silent at that point, and that piece of music will be withdrawn. Um, this is quite common. Sometimes you'll see on, as I say, on TikTok and Reels as well. Sometimes it will say, music removed due to challenge, which is quite a frequent thing. Where sometimes the music's just been put up there, and it turned out that the artist or the licensing group actually hadn't given permission, so therefore it's been challenged. But in this instance, there was a license agreement in place, and they've said they're taking it away. And why is that? Surprise, surprise, it's money. So the Universal Music Group has said that TikTok was proposing paying the artists at a rate that's a fraction of the rate that other major social platforms will pay. And it said that TikTok made up only about 1% of the total revenue that UMG was unable to pay to its artists. So think about all those millions of videos and loads of people looking at and enjoying that music. And in return for getting all those millions of people onto the platform, TikTok's then saying, we're going to only pay a tiny fraction and seemingly less than market rate in this instance to the music group, which would then be able to pass that on to the actual artists, the creatives who came up with the thing in the first place.
The flip side on this, however, is the fact that we have seen, specifically in the last couple of years, different artists rise in popularity due to their music being on TikTok. And while obviously in this story we're looking at the fact that because the music has been removed because they're not being paid ideally what they should be, but there is the flip side where it's like, okay, they're not paying what they should be on TikTok, but is there songs that are being used on TikTok then increasing their stream on other platforms such as Spotify, where licensing agreements are in place and they are being paid a comparatively fair amount? Because there is that other side where it's like, okay, well, it's a promotional thing, isn't it? If you are listening to the same kind of clip of the song that you are hearing on Reels, TikToks, etc., then is that not almost free advertising to an extent, because you are then free to stream the song or album, whatever, elsewhere?
Exactly, Amelia. That's a very good point, because we do have to remember that people can now consume their music in different ways. So, it's now very often a case that people are not tuning in to listen on the radio. Listenership for traditional radio and TV is falling. Hence, for example, those stations aren't able to actually get the advertising revenue that they used to, which becomes a bit of a vicious cycle. You then get increasingly people will hear, where are they going to hear their new music? Where are they going to hear that catchy
And
tune that
that's
sticks
just
in their
it.
head and they want to go buy? And that's just it. They'll get it through things like, either TikTok or the background of a YouTube video, or one of the other social media platforms. And in this instance, UMG is taking the gamble and saying, we think that our stars are of such value that we can they'll still be successful even though we don't have their music featuring on TikTok. But for a lot of artists, particularly those who are not in the global superstar Taylor Swift bracket, they'd be saying, well, you know what, we have to go on TikTok and we have to deal with what could be a very, very low level of the payment that comes from TikTok, but that's the price you pay in order to get the exposure to try and become more successful.
Well, that's another kind of aspect to this story, because there's a more recent artist, Tate McRae, and what she did was very clever in her most recent album release. And so what she did was she created a very small TikTok kind of music bite that was able to be used for loads of videos, and it took off with people using it predominantly in TikTok. So I'm going to focus on TikTok here for the story. And this created such a buzz around her music, and then that meant that her tour, that where tickets were released before the music and the full album came out, was sold out. So when you've got that level of marketing and the fact that, okay, you're teasing the music so that you can then sell out stadium tours, you've got that other aspect to consider here, that TikTok is being used as kind of a springboard platform to then launch careers or other things from it.
Exactly, and at the moment, given its exposure and the fact that it's certainly slowing up the youth market. You don't have young social media users flocking to join Meta's platforms; they're joining TikTok instead. So if you're chasing those youth listeners who are then going to go out and attend those gigs and sell out the stadiums on those tours, can you afford to cut off that TikTok exposure? That is going to be the calculation for many of these music groups and for many of these artists.
So that was our last discussion for this episode. But if you would like to hear more from us, including subscribing to our newsletter, as well as receiving information about subscriber-only podcasts, webinars, and events, then please subscribe to our premium via our Patreon channel using the link in the show notes. A big thank you to Anson Evaluate for helping to produce this podcast. And if you'd like to produce your own podcast, webinar, or you'd be interested to hear more about Anson Evaluate services, please take a look at their website that you can find at www.ansonevaluate.com. Just a reminder, these episodes are available on our website, YouTube channel, podcast channels such as Spotify, Apple Music, Amazon, and Google Podcasts, and please feel free to leave us a review. And finally, if you have any questions about anything that we've talked about today, please email us at admin@digitallawuk.com. Thank you for listening, and we hope to see you again next week.